Here is the contradiction at the heart of the International Criminal Court. It was created to prosecute the world's worst crimes, and the promise was simple: no one should be above the law. But the court has no police force, no army, and no way to force the most powerful states to cooperate. According to Karim Khan, who was serving as the court's prosecutor, one American senator put the double standard bluntly. Khan says Lindsey Graham told him the court was for Africa and thugs like Putin, not for democracies like Israel and the United States. We need to be careful with that claim. No recording of the conversation has been made public. This is Khan's account. Graham described his position differently. He argued that the court should respect national justice and deal with Israel in good faith. But the contradiction does not depend on one private conversation. Many Western governments supported the court when it issued a warrant for Vladimir Putin. When the court later pursued Israeli leaders, and when it investigated alleged crimes involving United States personnel, the United States answered with sanctions and pressure. So the real question is not whether international law exists. It does. The question is whether that law can reach everyone equally.
On the 17th of July, 1998, in Rome, 120 countries voted to create the first permanent international criminal court. 7 countries voted against it. 21 abstained. The vote was unrecorded, taken that way at the United States' request. So, no official record shows how any single country voted. The United States was, by its own account, one of the 7. Its lead negotiator said the treaty contains flaws that render it unacceptable. The treaty could not take effect until 60 countries had ratified or acceded to it. On the 11th of April, 2002, a group of states deposited their instruments together, taking the total beyond 60. The Rome Statute entered into force on the 1st of July, 2002. From that day, the court existed, but its reach ran only forward over crimes committed after that date. Today, 125 countries are states parties. The United States, Russia, and Israel are not among them. Each signed the statute. Each later informed the United Nations that it did not intend to become a party. The court was given 4 crimes to judge: genocide, acts intended to destroy, in whole or in part, a national, ethnic, racial, or religious group; crimes against humanity, murder, deportation, persecution, and other acts when they are part of a widespread or systematic attack on a civilian population; war crimes, grave breaches of the laws of war, including intentionally directing attacks against civilians; and the crime of aggression, the planning or execution by a state's leaders of an act of aggression that constitutes a manifest violation of the United Nations Charter. The amendments defining the crime of aggression were adopted in 2010. The court's jurisdiction over it was activated from the 17th of July, 2018, under narrower conditions than those governing the other 3 crimes. The court was never built to replace national justice. Under a principle called complementarity, it may act only when a country's own courts are unwilling or genuinely unable to investigate or prosecute the crime themselves. It is a court of last resort. On paper, complementarity is designed to preserve the primary role of national courts. And yet, there was, from the start, a serious objection, one that has never gone away. A treaty binds the countries that agree to it. The Rome Statute can reach further, It may exercise jurisdiction over the nationals of a state that never joined when the alleged crime was committed on the territory of a state party or of a state that accepted the court's jurisdiction, subject to the statute's other conditions. To its critics, that is, a court claiming authority over nations that never agreed to be judged. It is one of the strongest arguments made by the court's opponents, and it is not made only in bad faith. The United States made the point in the plainest possible way. It signed the treaty in December 2000. Then, in May 2002, it told the United Nations it did not intend to be a party and had no legal obligations arising from its signature. So this was the aspiration behind the Rome Statute: the same crimes, the same legal standards, and no immunity based solely on office or power, where the court possessed jurisdiction, whether the ability to enforce those standards was shared as equally as the law described them is the question the rest of this documentary sets out to answer. The Rome Statute built a court. Whether that court can act in any given case turns on two separate questions. The first is jurisdiction. Is this a matter the court is even allowed to touch? The second is enforcement. If it acts, can anyone make its decision real? Outside a Security Council referral, the court normally needs a territorial or nationality connection. Either the alleged conduct occurred on the territory of a state party, or of a state that accepted the court's jurisdiction, or the accused is a national of a state party. A case can begin in three ways. A member state can refer a situation to the court. The United Nations Security Council can refer one, or the prosecutor can open an investigation independently with the judge's authorization. There is also a way for a non-member state to supply a jurisdictional connection that would otherwise be missing. Under Article 12, Paragraph 3, a state that has not joined may lodge a declaration accepting the court's jurisdiction over specified crimes or a defined period. Ukraine did this twice before becoming a state party. Palestine also lodged a declaration before its membership took effect. The Security Council's power is the widest of all. A council referral can reach a country that never signed the treaty at all. That is how Sudan's Darfur reached the court in 2005, and how Libya reached it in 2011. Neither was a member. But the Security Council is governed by the veto. It has 5 permanent members, and each holds a veto. 3 of the 5, the United States, Russia, and China, are not members of the court. Any one of them can block a Security Council referral, even when every other jurisdictional route is unavailable. In 2014, France put forward a resolution to refer Syria to the court. 13 of the 15 council members backed it. 65 countries co-sponsored it. Russia and China vetoed it. Darfur had passed. Libya had passed. Syria did not. The same council that can open a door can also hold it shut. Suppose a case clears every one of those hurdles. The court cannot execute its own arrest warrants. It has no police force and depends on states and other cooperating authorities to arrest and surrender suspects. So, a warrant on its own is a piece of paper. It becomes real only when a state chooses to act on it, and stays paper when states refuse. Power enters the law twice. Once at the council table, where a veto can decide which non-party situations are allowed to reach the court through the Security Council, and again on the ground, where cooperation decides which of the court's warrants are ever enforced. This is the machinery. The next question is what it produced. For most of its first 2 decades, nearly everyone the court put on trial was African. That is true. It is where the charge, a court for Africa, comes from. How those cases reach the court is more complicated than the charge allows. Several of the court's earliest African situations were referred by African governments themselves: Uganda, the Democratic Republic of the Congo, the Central African Republic, and Mali. Each asked the court to investigate crimes on its own territory. In several self-referrals, critics argued that governments expected the court to focus principally on rebel opponents. Legally, however, a referral opens a situation, not merely the targets preferred by the referring government. These referrals demonstrate African agency, but they do not by themselves prove politically neutral enforcement. 2 more African situations came through the Security Council: Darfur in Sudan in 2005, Libya in 2011. Both reached the court because the council sent them, not because either country had joined. Others, the prosecutor opened directly, among them Kenya and Côte d'Ivoire. So the African docket did not come from a single door, it came from all of them. And behind the cases were real crimes and real dead. Child soldiers in the Congo, the Lord's Resistance Army in northern Uganda, the shrines of Timbuktu reduced to rubble, the killing in Darfur. None of that was invented. None of it should be forgotten to make a point about power. And the outcomes were not all alike. The court convicted some: Thomas Lubanga, Dominic Ongwen, Ahmad al-Mahdi. It acquitted others: Jean-Pierre Bemba on appeal after a decade in custody, Laurent Gbagbo. And some cases collapsed entirely. The charges against Kenya's president were withdrawn. Omar al-Bashir of Sudan was the first sitting head of state the court ever sought. His warrant issued in 2009. For years, he traveled and governed, and no member state arrested him. Before Rodrigo Duterte's transfer in March 2025, every person held in ICC custody had been African. His transfer created the strongest non-African custody counterexample to the court's earlier record. So the docket was African, but not only because the court chose Africa. Sometimes Africa chose the court. And that is exactly why self-referral does not settle the larger question. The question was never whether African crimes were real. They were. It was whether the same standards would be enforced beyond the places where cooperation was politically possible. For 2 decades, the court's custody and completed case record remained concentrated on Africans, while many suspects protected by non-cooperation, powerful allies, or greater state capacity remained beyond its reach.
Sometimes Africa chose the court. That was where the last chapter ended. This chapter is about what that choice actually meant and what it could not control. The term lawyers use is self-referral, and it can mislead. No government referred itself for prosecution. Under the Rome Statute, a member state refers a situation, a place and a period in which grave crimes appear to have been committed. It asks the prosecutor to investigate that situation. Who ends up charged is, in law, not the government's decision. Consider Uganda. In December 2003, President Yoweri Museveni took the decision to refer the situation concerning the Lord's Resistance Army to the new court. In January 2004, the referral was announced in London at a joint press conference with the prosecutor. The name of that referral matters. It pointed at the rebels his army had been fighting for years. Uganda promised cooperation in locating and arresting the rebel leadership and spoke of amending its amnesty law to exclude that leadership. This was not a passive act. A government invited an international court onto its own territory, on its own initiative, at a moment of its own choosing. The court took the invitation, but not the label. When the prosecutor opened his investigation in July 2004, it covered the broader situation in northern Uganda, not only the enemy named in the referral. That is the legal point. A referral opens a situation. It does not deliver a target list. The Congo followed within months. In March 2004, the government of President Joseph Kabila referred the situation of crimes committed anywhere on Congolese territory. The Central African Republic did the same at the end of that year, and then a second time in 2014. Each of these was a deliberate governmental act. Why invite the court in? For human rights organizations, it created another possible route to accountability. Governments could also see advantages. An international prosecution of rebel enemies carries a legitimacy that a domestic one does not. Critics argued, at the time and since, that governments expected the court's attention to fall principally on their armed opponents, while their own forces stayed beyond its practical reach. That criticism had substance behind it. In February 2004, Human Rights Watch publicly reminded the prosecutor that Uganda's referral did not limit the investigation to crimes by the rebels, and that serious abuses by government forces were documented too. In Uganda, the record shows both truths at once. The court tried and convicted a rebel commander, Dominique Ongwen, for crimes committed in the north. Every warrant it issued in the Uganda situation named a rebel commander. None named a government soldier. Whether that reflects the evidence, the law, or the limits of cooperation is exactly the kind of question a referral cannot settle by itself. And none of this makes the choice less African or the crimes less real. To describe every self-referral as Western pressure would erase the strategy of the governments that made them and the demands for accountability that also came from outside government. A government can make a real choice for reasons that are neither neutral nor externally dictated. So, self-referral explains how the court arrived. It does not explain everything the court then did or failed to do. And it says nothing about the places no government ever invited it into. In 2011, the court entered Libya through a different door. The Security Council sent it there. What happened next is the next chapter. Libya was not a state party to the court in 2011. At the time of the uprising, it had neither ratified the Rome Statute nor accepted the court's jurisdiction. Under the rules you have already seen, that should have kept its leaders out of reach. But the statute left one door open. In February 2011, as Libyan forces fired on an uprising, the Security Council walked through it. On February 26, 2011, the Council adopted Resolution 1970 unanimously. It referred the situation in Libya since February 15th to the prosecutor of the International Criminal Court. The same resolution froze assets, banned travel, and embargoed arms. But the referral itself did one precise thing. It gave the court jurisdiction over alleged crimes in a country that at that time had not accepted the court's jurisdiction. It authorized lawyers, not force. The prosecutor opened the investigation on March 3, 2011. By June 27th, the judges had issued 3 arrest warrants for alleged crimes against humanity: Muammar Gaddafi, his son Saif al-Islam, and the intelligence chief Abdullah al-Senussi. Warrants, not verdicts. No trial had begun. The legal track was moving. 3 weeks after the referral, the council acted again, and here the story splits in two. On March 17, 2011, Resolution 1973 authorized member states to take all necessary measures to protect civilians and civilian-populated areas under threat of attack, and it established a no-fly zone with specified exceptions, including humanitarian flights. It expressly excluded a foreign occupation force of any form on any part of Libyan territory. This vote was not unanimous. 10 in favor, none against, 5 abstentions: Brazil, China, Germany, India, and Russia. Understand what now existed. Resolution 1970 was the legal door. Resolution 1973 was the military one. 2 resolutions, 2 different acts. The law keeps them separate. So will this film. Airstrikes began on March 19th, flown first by a coalition of member states. By March 31st, NATO had taken sole command of what it called Operation Unified Protector, the no-fly zone, an arms embargo enforced at sea, and strikes flown, in NATO's stated words, to protect civilians. The campaign lasted 7 months. Whatever its stated purpose, its cumulative effect was to break the military power of the government whose senior officials the court was investigating. Tripoli fell in August. In October, Muammar Gaddafi was captured and killed. No court ever tried him. On November 22, 2011, his case was terminated. Not acquitted, not convicted. Terminated because the defendant was dead. Hold both tracks in view. In the same 8 months, the Security Council opened 2 different tracks. Resolution 1970 referred the situation. The court's judges later issued the warrants. Resolution 1973 authorized military force. Coalition aircraft carried out the campaign. The referral did not authorize the war, but both became part of the same political sequence. So what did the legal track deliver? Muammar Gaddafi died without any verdict. Saif al-Islam Gaddafi was never surrendered, and no trial ever began. In February 2026, he was reported killed at his home in Libya. The court has not formally closed his case. That decision waits on an official death certificate. Abdullah al-Sanusi's case was ruled inadmissible in 2013, confirmed on appeal in 2014, because Libya was prosecuting him itself. Count it plainly. Not one Gaddafi-era official ever sat in the court's dock in The Hague. And the winners? The United Nations Commission of Inquiry documented unlawful killings, torture, enforced disappearances, and pillage by anti-Gaddafi fighters, and found them targeting whole communities, Tuarega among them. It recorded scores of captured loyalists executed at Sirte in October 2011. That evidence was gathered, published, and put before the Human Rights Council. It was not invisible. It was simply never matched by warrants. The comparison is stark. Every warrant issued during the 2011 war named a Gaddafi-era official. 3 warrants, 1 side. The Libya docket did widen later. A militia commander wanted in 2017 for crimes committed years after the revolution. 6 further warrants unsealed in October 2024. And Khaled el-Hishri, a prison commander transferred to The Hague in 2025. On the 16th of July 2026, judges confirmed all 17 charges against him and committed the case to trial. That was not a verdict. The charges concern alleged crimes committed between 2014 and 2020, not the anti-Gaddafi crimes of 2011. 14 warrants since 2011, 1 man in custody, and still not 1 warrant for the crimes of the anti-Gaddafi forces of 2011. Now the counter-argument, and it deserves full weight. The court did not authorize the war. Resolutions 1970 and 1973 were separate legal acts, 3 weeks apart, with different votes. NATO did not fly for the prosecutor, and the prosecutor did not report to NATO. The same commission that documented rebel crimes described NATO's campaign as highly precise overall. It also documented 60 civilian deaths across 5 strikes it investigated and questioned the evidence behind several of NATO's target descriptions. The evidence against Gaddafi's forces was serious and independently documented. Western interest in his fall does not make the crimes of his government fictional. And a political sequence is not, by itself, a conspiracy. Nothing in the two resolutions or the ICC record establishes that the referral was designed as an escort for regime change. And still, critics argue, Libya taught a lesson no statute wrote down. Accountability arrived in the same envelope as intervention. Same council, same weeks, same governing power. The warrants pointed at the leadership. The air campaign broke the military force beneath it. Not through one legal command, but within one political sequence. For governments watching, the line between a court and a coalition became very hard to see. That perception followed the court out of Libya, and it never left. The war ended with the Gaddafi government overthrown and no Gaddafi-era ICC case reaching trial in The Hague. What filled the space it left behind is another story, and it has to be told carefully, cause by cause. That is the next chapter. In the autumn of 2017, 6 years after the intervention, a television news team carried hidden cameras into a property outside Tripoli. What they recorded was an auction. The goods were human beings. The journalists were a CNN team led by Nima El-Baghir, with producer Raja Razik, investigating reports of migrants being sold. They watched a dozen African migrants auctioned. The reporting won a George Polk Award. It is attributed dated journalism. The camera did not stand alone. Months earlier, the International Organization for Migration had described slave market conditions on the migrant routes. Young men sold and bought and held for ransom. After the footage aired, United Nations experts said it plainly. Slavery is an outrageous reality in Libya. None of this happened in a vacuum. A year earlier, the United Nations had reported a breakdown of Libya's justice system, a state of impunity in which armed groups, criminal gangs, smugglers, and traffickers controlled the flow of migrants. Migrants were arbitrarily detained, tortured, and forced to work. Authority was fragmented. Opportunity was not. Now the limitation, and it deserves equal care, racism against Black Africans, abusive detention, and the exploitation of migrants existed long before 2011. Researchers documented racist violence and arbitrary arrests under the old government. The referral did not create slave markets. No air campaign by itself explains everything that followed. What changed was the state around the abuse, weaker, more divided, easier for armed and criminal networks to use. But sequence still has weight. 6 years after the intervention, journalists documented human beings being auctioned in the country the intervention had left behind. The next chapter follows the court, beyond Africa, where its jurisdiction expanded but custody still depended on a state deciding to cooperate. The last chapter ended with a question. The court's jurisdiction was expanding beyond Africa, but custody still depended on a state deciding to cooperate. This chapter tests that question on a single case. The case of Rodrigo Roa Duterte, former president of the Philippines. The Philippines became a state party to the Rome Statute on the 1st of November 2011. On March 17, 2018, its government deposited a written notification of withdrawal. Article 127 of the statute gives withdrawal effect 1 year later, and on March 17, 2019, the Philippines ceased to be a state party. But the treaty does not treat withdrawal as an eraser. On the court's reading, jurisdiction survived for alleged crimes committed while the Philippines was bound, from November 2011 to the 16th of March 2019. Withdrawals ended the court's reach into the future. It did not close the past. In September 2021, Pretrial Chamber 1 authorized an investigation into killings in the so-called War on Drugs campaign. The Philippines asked to defer to its own authorities, and the investigation paused. In January 2023, the judges authorized its resumption. The Philippine government appealed. In July 2023, The appeals chamber confirmed the resumption by a majority. 2 judges dissented. In their view, the court could not exercise jurisdiction because withdrawal had taken effect before the investigation was argued. The majority did not decide that question on its merits. It survived, unresolved, into everything that followed. On February 10, 2025, the prosecutor applied for a warrant against Duterte for the crimes against humanity of murder, torture, and rape. The judges issued a narrower warrant. On March 7, 2025, under seal, Pretrial Chamber 1 found reasonable grounds to believe that Duterte was responsible as an indirect co-perpetrator for the crime against humanity of murder. 4 days later, the warrant was made public. A warrant is a judicial finding at the reasonable grounds stage. It is not a verdict. Then came the step no chamber can order into existence. The court did not arrest Rodrigo Duterte. It cannot arrest anyone. Officers of the Republic of the Philippines arrested their own former president, acting on the court's warrant. On March 12, 2025, he was surrendered to ICC custody in The Hague. Keep those 3 acts separate. A court issued a warrant. Philippine authorities executed it. The state then surrendered him. 2 days later, he appeared before the judges by video link. His defense went for the foundation. The Philippines had withdrawn, counsel argued, so the court had no jurisdiction to try him at all. In October 2025, Pretrial Chamber 1 ruled that the court may exercise jurisdiction over alleged crimes committed while the Philippines was still a state party. In April 2026, the appeals chamber confirmed that ruling by majority, with 1 judge dissenting in part. The judges read the statute's jurisdiction articles together with Article 127, the withdrawal clause. The majority held that withdrawal could not erase jurisdiction over alleged crimes from the Philippines' treaty years. But neither could the court reach a former member forever. Withdrawal was real. It was not retroactive. The defense also argued that Duterte was not fit to stand trial and asked for an indefinite adjournment. The judges postponed the confirmation hearing, and a panel of 3 independent medical experts assessed him. In January 2026, the chamber found him fit to take part in the proceedings. The confirmation hearing ran from 23rd to 27th February 2026, in his absence and at his own request. On 23rd April 2026, the judges unanimously confirmed 3 counts of crimes against humanity, of murder and attempted murder, and committed him to trial. That is where the case stands. The trial is scheduled to open on November 30th, 2026. It has not begun. Confirmation is not conviction. Rodrigo Duterte is presumed innocent unless and until the prosecution proves its case before the court. Within the same ICC situation, a second warrant tells the other half of the story. A warrant against Ronald De La Rosa, the former national police chief, was unsealed in May 2026. He remains at large and is also presumed innocent. Same court, another warrant, a different custody outcome. Set the Philippines beside Libya. In Libya, jurisdiction arrived by Security Council referral in 2011, and the first Libya suspect did not enter ICC custody until December 2025. In the Philippines, Duterte entered ICC custody 5 days after the warrant was issued, even though jurisdiction was contested all the way to the appeals chamber. A decisive difference in custody was cooperation. Jurisdiction survived withdrawal. Custody arrived through cooperation. The court could issue the warrant. A state still had to carry it out. The next chapter follows what happened when the court's reach touched a close ally of the United States. On November 21st, 2024, Pretrial Chamber 1 did 2 kinds of work. First, it rejected 2 Israeli applications, a request for a new Article 18 notice and an Article 19 jurisdiction challenge it treated as premature. Second, it issued warrants for Benjamin Netanyahu, Prime Minister at the time of the relevant conduct, and Yoav Gallant, Minister of Defense at the time of the alleged conduct. Keep the procedural rulings and the warrants apart. What followed tested both. The chamber found reasonable grounds to believe that each man bears criminal responsibility as a co-perpetrator for the war crime of starvation as a method of warfare, and for the crimes against humanity of murder, persecution, and other inhumane acts from at least October 8, 2023 until at least May 20, 2024. That is the warrant threshold. It is not proof beyond reasonable doubt. No charges have been confirmed. Neither man has appeared before the court. Both are presumed innocent. The chamber was also handling the other side of the situation. It issued a warrant for Mohammed Diab Ibrahim al-Mazri, known as Daif, the highest commander of the military wing of Hamas, for crimes against humanity and war crimes allegedly committed from at least 7 October 2023. On 26 February 2025, the chamber terminated those proceedings after the prosecution notified it of his death. The docket names Israeli leaders and a Hamas commander. An account carrying only one half is not the docket. Israel's objection deserves Israel's own words. Israel is not a state party. It signed the Rome Statute in 2000, then told the treaty depositary in 2002 that it did not intend to become a party. Its argument is not simply that it stands outside the treaty. It says Palestine could not delegate jurisdiction it never held. In its filing, Israel stated, Palestinian jurisdiction over Israeli nationals was not previously possessed or subsequently relinquished. The two challenges followed different paths. Article 18 concerned whether the prosecutor had to issue a new notice before investigating conduct after October 7, 2023. In December 2025, the appeals chamber rejected Israel's appeal and held that no new notice was required. Article 19 concerned jurisdiction. The chamber initially treated that challenge as premature because no warrant had issued, without prejudice to a later challenge. In April 2025, the appeals chamber reversed and remanded for a ruling on the substance. That jurisdiction question remains undecided. In July 2025, the chamber rejected Israel's request to withdraw the warrants. In October, it refused leave to appeal. Then came the response. It belongs in a different column. In Washington, the House passed H.R. 23, a bill to sanction the court. On January 28, 2025, the Senate failed to advance it. 9 days later, the President signed Executive Order 14,203. The order invoked presidential authorities, including the International Emergency Economic Powers Act and the National Emergencies Act. On the 13th of February, the prosecutor, Karim Khan, was placed on the sanctions list. Congress had not enacted H.R. 23. The executive acted through a different legal route. What that instrument grew into belongs to a later chapter. Attribution matters here. On May 20th, 2024, the day he announced the warrant applications, Khan said on camera that one senior leader had told him, "This court is built for Africa and for thugs like Putin." He named no one. A Foreign Office Freedom of Information response later confirmed a 23 April 2024 call between the Foreign Secretary and the prosecutor. The call is confirmed. Its content is not. A source close to Cameron described it as robust and said he was relaying pressure within his party, not issuing a threat. None of this reaches an arrest. The court cannot make one. In its own words, it has no police force or enforcement body and relies on cooperation with countries, particularly for arrests. The warrant still had to meet a state. In April 2025, Netanyahu visited Hungary, a state party, and was not arrested. The chamber later found Hungary had failed to comply and referred the matter to the Assembly of States Parties. Hungary then gave notice that it would leave the statute. 4 days before that withdrawal would have taken effect, it revoked the notice. Hungary never ceased to be a state party. So keep the two columns apart. The court's legal act was issuing warrants under its statute and claimed jurisdiction. The response was an exercise of diplomatic, legislative, and financial power. Political opposition does not establish that a warrant was sound. A warrant does not establish guilt. Opposing the court is not itself a crime. What the record supports is narrower. The court's paper reached a close ally of the United States. It did not produce a single arrest. The next chapter goes to a place the court could not reach at all.
That place is Minab.
On February 28, 2026, the first morning of the 2026 war, a missile hit the Shajara Tayyebe Primary School in Minab, in Hormozgan province. Classes were in session, and most of the dead were children. The count was disputed from the first day. That day, the Secretary General told the Security Council a strike had killed at least 85 people at a girls' school. Iranian authorities put the figure higher, at more than 175 killed. By July, an independent investigation had identified 157 of the dead by name, 123 of them children under 14, and put the toll between 157 and 168. Each figure carries a source and a date, and the public record has not converged on one final total. Who fired is a separate question from how many died. Reporting and weapons analysts attributed the school strike to a United States cruise missile, a weapon only American forces in this war fielded. An initial internal United States assessment reportedly found American forces likely responsible, on outdated intelligence that still tied the building to a military compound next door. As of July 21, 2026, the Pentagon had released no final findings. Central Command was reviewing them, and its stated position was that the investigation was ongoing. Israel has denied any role. The American president has denied that the United States was responsible. Even if the strike was American, that does not settle whether it was unlawful. And unlawful is not the same as criminal. The law of armed conflict does not forbid every attack that kills civilians. It asks a sequence of questions. Was the object of the attack a military target or the school? A school is a civilian object unless reliable information indicates it has become a military objective. Were targeting decisions made in good faith on the information reasonably available, with feasible precautions to verify the target? If those rules were broken, the strike was unlawful, which engages the responsibility of the state. A war crime asks for more: a guilty mind, an attack directed at civilians or launched in the knowledge that the civilian harm would be clearly excessive. A genuine mistake about the target, even a careless one, can break the law of targeting while falling short of that criminal threshold. Serious analysts divided. Amnesty International said the strike must be investigated as a war crime. Human Rights Watch said it could be one if recklessness were shown. A detailed legal analysis found it unlawful, yet likely below the threshold a criminal charge requires. The seriousness of an allegation and the proof of a crime are different things. Set the question of a crime aside. If it were one, could the International Criminal Court hear it? The court is not a world court with power everywhere. Under the Rome Statute, it can ordinarily act only on an Article 12 nexus: the conduct on a state party's territory, or its alleged perpetrator a state party's national. That nexus can also come from a declaration under Article 12(3) by a state outside the treaty. A state party referral and an investigation begun by the prosecutor are triggers, not substitutes for that nexus. One route bypasses Article 12 entirely: a Security Council referral under Article 13(b). Now, apply that to Minab. The alleged conduct occurred in Iran, which signed the Rome Statute in 2000 and never ratified it. So Iran is not a state party. Any alleged perpetrators, on the reported attribution, would be United States nationals. The United States signed in 2000, told the depositary in 2002 that it would not become a party, and is not a state party either. Neither a state party referral nor the prosecutor acting alone can supply the missing nexus, and the court's work on the situation in Palestine is territorial to Palestine and does not reach conduct in Iran. On its ordinary machinery, neither nexus is available. Two possibilities remain, and neither is presently in effect. As the territorial state, Iran could lodge an Article 12.3 declaration accepting the court's jurisdiction over this event, even as a non-party. Lawyers and rights groups have urged Iran to accept the court's jurisdiction. But as of 21 July 2026, Iran appeared on neither the published list of declarations lodged under Article 12.3, nor its situations page. The second is a Security Council referral under Article 13b, which reached Sudan in 2005 and Libya in 2011, both outside the treaty. No Minab referral has been adopted. Under Article 27, a referral would need 9 of 15 votes and no permanent member's veto, the United States among the 5. In both referrals, the Council placed contributing non-party states' nationals under their own state's exclusive jurisdiction for acts connected to the operations, unless waived.
The law is written for everyone. The power to hold it at arm's length is not. The door is not held by one state alone. Iran could still accept the court's jurisdiction, while the United States' non-party status closes the nationality route, and its veto commands the only external bypass. A state may investigate or prosecute its own personnel, but criminal liability depends on the applicable offense and its mental element. Another state's courts may claim universal jurisdiction, but that depends on national law, custody rules, and applicable immunities. Sanctions and condemnation are pressure, not a verdict. Keep two things apart at the end. That the court cannot reach a case is not a finding that no crime occurred. It is a statement about jurisdiction and power, not about guilt. The absence of a court does not make an act lawful, and the presence of one would not make it criminal. What happened at Minab is still being established, and what the law would make of it is still open. What the record settles is narrower. The law was written for everyone. The reach was not. The next chapter turns from a court that could not reach in to the pressure closing on the court itself.
The last chapter ended at a closed door in Minab. For most of this film, the court has reached toward power. Here, power reaches back. The ICC has no police force and no territory of its own. It depends on states for arrests and evidence, and on banks, insurers, travel systems, and private technology to keep its work moving. Pressure does not have to rewrite the Rome Statute to matter. It can reach the people and systems the court depends on. The clearest external pressure has come from the United States, which is not a state party. On 6 February 2025, President Trump signed Executive Order 14,203, authorizing asset freezes and entry restrictions against people the United States says helped the court pursue Americans or their allies. A week later, Karim Khan was placed on the sanctions list. 4 sitting judges were added in June 2025, and further designations followed. These are executive sanctions. They are not criminal charges or legislation passed by Congress. The House of Representatives passed a bill targeting the court by 243 votes to 140. But Senate cloture on the motion to proceed failed by 54 votes to 45, with one senator not voting. So the bill did not become law. On July 13, 2026, the State Department announced what it called a whole-of-government response intended to disable the court's ability to operate. An executive sanction, a failed legislative route, and a diplomatic campaign are different instruments. Only the sanctions were then operative legal measures. In law, The sanctions block property held within United States reach and prohibit United States persons from dealing with those designated. In practice, sanctioned judges say they lost access to bank accounts, credit cards, and health insurance, while the court faced reported problems with banking and software. That is real pressure. It is not proof that the court has been shut down. The court calls the measures unlawful, and in June 2026, 3 of its judges sued the United States to overturn them. Inside the institution, the strain ended in removal. On July 24, 2026, the Assembly of States parties voted by secret ballot to remove Karine Khan under Article 46. 82 states parties found serious misconduct and serious breach of duty. Khan denies wrongdoing, and his lawyer says he will challenge the decision. Deputy prosecutors Najat Shamim Khan and Mame Mandiai Nyang continue to lead an office that says its work continues uninterrupted. Existing warrants remain because only ICC judges can withdraw them. The removal was disciplinary, not a criminal conviction. It occurred amid external political and sanctions pressure, but the reviewed public record does not establish causation. Internal accountability and external pressure now coexist. Pressure also runs through the door states can open or close. Cooperation. The court cannot arrest anyone itself, so when a state refuses to act, a warrant can simply sit. Some states have also moved toward withdrawal. Hungary gave notice in 2025, then withdrew it on May 29, 2026, 4 days before it would have taken effect. Hungary never left. Niger, Burkina Faso, and Mali gave notice in June 2026, but their withdrawals do not take effect until June 2027. Venezuela notified withdrawal on July 24, 2026. Under Article 127, it remains a state party for 1 year. Until then, all 4 remain states parties and remain bound by the treaty. Withdrawal does not erase obligations incurred while a state was still a party. Despite all of this, the court has continued to work. It confirmed charges of crimes against humanity against former Philippine President Rodrigo Duterte and scheduled his trial to open on November 30, 2026. It continued to issue warrants and rulings. 3 judges challenged the sanctions in court. The system still included 125 states parties. The evidence supports neither triumph nor collapse. The court is constrained, but still operating. The court's authority is written in law, but its practical reach depends on state cooperation, financial systems, and officials willing to act. That reach can be narrowed without changing a word of the statute. The court has not been silenced. But the pressure has exposed how much universal law still depends on unequal power. The final chapter asks the question beneath every case we have seen. When the law is written for everyone, but the power to enforce it is not, who answers for the gravest crimes?
That question is run under every chapter of this film. It does not have a comfortable answer. Again and again, the same written law reached some people and slid past others. The difference was the distribution of power. Begin with what the Rome Statute genuinely changed. There had been international trials before, but at the international level, earlier tribunals were generally created for particular conflicts and periods, standing up after the fact and closing when their work was done. The statute created the first permanent international criminal court, open to any state that joins and able in principle to investigate any person, up to a head of state, for crimes within its jurisdiction. Article 27 denies official capacity as a legal exemption within the statute, even as jurisdiction and enforcement can still be constrained by unequal power. That was a real change, and this film has never pretended otherwise. But the statute did not hand the court the world. Its jurisdiction rests on conditions. Ordinarily, the court can act only where the conduct occurred on the territory of a state party, or where the accused is a national of one. A state outside the treaty may accept jurisdiction for a single situation through an Article 12(3) declaration. A Security Council referral can bypass those territorial and nationality preconditions. Each route still turns on a decision the court does not make: a state's choice to join, a state's choice to accept jurisdiction, or a council vote in which 5 permanent members hold a veto. Even where jurisdiction exists, the court cannot enforce it alone. It has no police force and no territory of its own. For arrests, evidence, and custody, it depends on states. This film showed both faces of that dependence. Where a government executed a warrant against its own former president, the court reached him within days. Where a warrant met a state that would not act, it could sit unenforced. Leaving a treaty by its own terms is lawful. Failing to comply with a binding cooperation obligation while still bound is non-compliance, and the two are not the same. This is where the asymmetry shows. The legal language is equal. The capacity to refuse it is not. Power operates through different levers: non-party status, withheld cooperation, sanctions against court officials, and the Security Council veto. When the court reached toward a close ally of a permanent member, it could issue warrants but not compel an arrest, and the reply was sanctions and pressure, not surrender. Coercive pressure aimed at a court can strain the independence that makes its judgments worth anything. Equal on the page, the law meets a world of unequal leverage.
It is tempting to draw the bitter conclusion: if the powerful escape, the whole thing is a fraud, and its cases are victor's justice against the weak. That does not follow. A warrant that cannot reach one person is no reason to cancel one that can reach another. A case supported by evidence and law does not become unjust because a better shielded suspect is never charged. Criticism of the court can be fair, and resistance to a case, however fierce, is neither proof of guilt nor proof of innocence. Selectivity is a genuine problem of legitimacy. It is not by itself a defense for any accused. So hold on to what incomplete justice can still do. It can bring a former president before the court, where evidence can be tested in public proceedings. It can build a documented record that outlives the politics of the moment, and affirm in law that official rank does not erase criminal responsibility. The court was never meant to act alone. Under its statute, it complements national criminal jurisdictions and may act when relevant national proceedings are absent or not genuine, including because a state is unwilling or unable genuinely to carry them out. Accountability also runs through national courts, including universal jurisdiction cases and through hybrid tribunals. None of that ends impunity. All of it is more than nothing. But keep the account honest. Incomplete reach cannot be called equal enforcement. A system that reaches the cooperative and the weak more readily than the protected and the strong has not delivered one law for all. It has delivered as much of that law as power allowed. Jurisdiction is not guilt, and the absence of jurisdiction is not innocence. A case never brought settles nothing about what did or did not happen. The court that emerges is neither omnipotent nor irrelevant. That it can be pressured and that its officials can be subjected to institutional accountability does not make it a fraud. It is an unfinished instrument, real where it reaches. The danger is not in admitting that gap. It is in dressing partial justice as universal justice and calling the reachable the same as the just. So the answer is not to abandon the law when it reaches only some. It is to pursue every case that can be supported by evidence and law, while refusing to mistake partial accountability for equal justice. International criminal law is real, and it matters, but it does not yet operate universally. The law was written universally. The power to refuse it was not.